Welcome, everyone. My name is Sally Mewis. I head up the technology and digital practice at Walker Morris. And in the next hour or so, we're going to be talking about artificial intelligence. For those of you who've been following our recent programs of tech and digital webinars, you might be saying to yourself, they're talking about artificial intelligence again. And yes, we are. And that's because that's what our clients are talking to us about. That's what everyone's talking about. Clients are coming to us asking us for guidance and advice on all aspects around AI, and particularly, I think, around intellectual property and sort of general contracting mechanisms. And so what we're going to do in the next 45 minutes to an hour is just look at one aspect of this technology, and that's around IP. And IP, I think, is becoming increasingly significant when people are starting to look at artificial intelligence. And that's in part because there's a huge amount of data involved in it, and people are concerned about rights around data. And I think it's quite interesting, actually, as a sort of seasoned technology lawyer, negotiating lots of licenses and outsourcing agreements. IP has almost taken a back step in terms of general contracting positions, and it's not necessarily hugely significant in most software as a service outsourcing agreements. I think that's going to change actually quite significantly with artificial intelligence, and that's what we're going to be looking at and debating with two of my colleagues who I'll introduce in a moment. Before we get into the detail of intellectual property in AI, I just thought it was worth, I'm a big fan of sort of going back to basics on some of this stuff. And I think artificial intelligence is a word that's bandied around so much now. It means different things to different people. Sometimes it's confused with robots. We're not talking about robotics and automation on this webinar. We're actually just talking about artificial intelligence. And when we talk about that, we are talking about the broad field of machines displaying logic and reasoning abilities like humans. When we talk about artificial intelligence, we typically then split it down into subcategories. And again, I think this is where it can get quite confusing. In my head, artificial intelligence is the big bubble of everything that is associated with a machine behaving like a human and displaying that logic and reasoning that I just mentioned. And then machine learning is basically where the machine learns from data and then can make decisions based on that learning. And that's where we're seeing a lot of activity in lots of different use cases currently. Deep learning, which is kind of a mini, in my head, again, a mini subset within artificial intelligence. If it's a kind of bubble, it's the bit in the middle. And deep learning is really a form of artificial intelligence that use artificial neural networks that can use data to make intelligent decisions. So that is the really, really clever stuff. And whilst we are seeing evidence of that being used in various areas, my sense is that that is still got quite a long way to develop. Both machine learning and deep learning neural networks do require powerful algorithms, and you'll hear people talk a lot about algorithms in artificial intelligence. When I think about this, in terms of sort of use cases that we're seeing now, and let's talk about some real life examples because I think it's helpful. Siri, Alexa uses machine learning algorithms to understand instructions and questions. Amazon uses machine learning of the kind that's sometimes referred to as continuous estimation. So it's analysing what people might buy, making suggestions to customers about what they might like to buy based on past behaviours. So all of that continuous estimation, optimization, classification is something a truck or a car, clustering, putting things into categories. Those kind of, in my mind, fall into the category of machine learning. We're seeing lots of activity around that. But of course, it is all part of this artificial intelligence revolution boom, whatever you like to say, even though when we were talking about this in the rehearsal, Matt Lingard, who's going to be talking in a minute, said to me, it's been around since the 1950s, Sally, it's not really that new. So as with a lot of these things, when you start to talk about emerging technologies, and we've seen that, we saw that when software first was around in the 1980s, the law always straggles behind. Inevitably it does, because there are complex issues. And particularly with artificial intelligence, there are complex moral issues as well. I mean, we're not going to talk a lot about driverless vehicles, but clearly driverless vehicles use a lot of artificial intelligence. And there are lots of complicated data sharing issues, moral issues, and of course intellectual property. And I'm absolutely delighted to be joined by two of my colleagues, Alan, who heads up our intellectual property team, and Matt, who's a very experienced IP lawyer, and they are going to help us get to the bottom of kind of where we are really in terms of intellectual property right now as it relates to artificial intelligence, and think about some of the challenges that if we are signing up to contracts, if we are doing some work around AI, what do we need to be thinking about? What do we need to be careful about? Data is obviously a big issue. This is just one little health warning before we get going. Data is a massive, massive issue. Personal data is a massive, massive issue in artificial intelligence. We're not really going to be talking about that specifically. We are going to be talking about data as an asset, but not GDPR-related things. We'll probably cover that in another session. Okay, so I've introduced Matt and Alan. I'm very, very grateful for them taking the time to talk to us about all this stuff, because it's complicated and there's lots going on. Let's start with you, Matt. Could you just talk to us, again, going back to basics and really helpful, what IP rights are there that are relevant to artificial intelligence?
Thanks, Sally. Hello, everyone. So we're quite both fortunate and unfortunate in the UK that the law itself is relatively sluggish when it comes to technology. So we're lucky in the sense that we therefore know we have a very fixed set of rules to apply to this ever-changing technology. So fundamentally, when we look at AI, we take it down to its very basic form, and fundamentally to us, it's a work of software. So we have well-established principles for dealing with software in the UK, and we treat them fundamentally as a work of copyright. So we break it down to its ones and zeros and its lines on the page. Copyright's a very long-standing and well-developed right. Admittedly, I don't think that the people who drafted the Copyrights Act would have had artificial intelligence in mind when they did it. But it does allow us to approach AI with a little bit of clarity, though it's not always perfect. So copyright being the major one, the usual rules of copyright apply, in that whoever creates the work fundamentally is going to own it, unless that position is changed through a signed agreement. So traditionally that can be employers, alternatively if that right has been assigned or it's been licensed. And copyright is therefore infringed by, again, the traditional means of copying either of a large part of the work or a key critical element of the work, which that does pose quite a fundamental challenge in that AIs themselves are very difficult to fix. How can you say that something that is constantly changing and developing can ever be copied line by line? So you can see there as we start to kind of, one of the first challenges thrown up by an artificial intelligence. Looking at some of the other areas, patents is obviously an obvious one. And when we talk about artificial intelligence and patents, we think about two things. Number one, can you actually patent the concept of an artificial intelligence itself? Going back to the first point I made, artificial intelligences are considered at the moment as pieces of software. And though we acknowledge that our kind of coverage of software in this jurisdiction is a bit rubbish, and we don't allow technically for the patenting of software as such, it's specifically excluded. You are able to seek patents for software if that software has what we refer to in the field as a direct technical effect. It actually has to have a physical real-world impact. Examples of this include pieces of software that make computers run faster, pieces of software that can allow high-resolution images to be kind of deciphered and created. To give you an insight into kind of how attractive this area is for people who are in the business of filing patents, in the year 2017, around 30,000 patents were filed worldwide for artificial intelligence-related inventions. the reason why I'm quoting 2017 figures is because patents themselves are kept confidential for a large amount of time, usually from about 18 months. So a lot of the data text is very slow to come out. But what we are seeing is this massive upward trend in people seeking protection for software, for artificial intelligences through patenting. Your key players in this area are obviously Google, Apple, and Nokia are also heavily involved in the kind of the patenting of this area. The other element that we think about when we think about patents and artificial intelligences is what about things that artificial intelligences create? We create these machines to do very clever things, to quite often solve problems that we ourselves can't solve. At the moment, and we'll come on to discuss this a little bit later in terms of how the law deals with recent developments in terms of artificial intelligences and patents, but is an area of key concern is kind of how we are going to deal with this area of inventions that have been created by artificial intelligences. Just picking up on the last two areas of intellectual property, which probably aren't as relevant, but I think still are worth consideration. We have obviously the design system. I don't think that's really relevant for artificial intelligences unless they start designing some pretty clever stuff, which could happen, but we've not crossed that bridge yet. And finally, I think trademarks. Trademarks is not one that I think you would immediately look to for artificial intelligences. However, there is a question of identity when it comes to artificial intelligence. Google have created a fantastic brand and identity around their DeepMind software, and there could be a question, in my view, later as we develop kind of, how is that duality of it, artificial intelligence as a brand, but also as a legal person could develop. And I think fundamentally as well, when we get to trademarks, as Google are the market leader at the moment, as they've suffered in the past with generality, Google becoming such a generic term, could DeepMind become a generic term for artificial intelligences as it kind of spawns off its various very clever artificial children in the future? We'll have to wait and see, but those are kind of the key IP rights in my view that are relevant to AI at the moment.
We're going to talk in a minute, Matt, about what's going on in the legal community around IP and what developments we're likely to see. But just before we do that, it struck me when you were talking about the patents. I mean, clearly it's harder to register a software as a patent in Europe and the UK than in the US. Do you think that's going to be a disadvantage to the UK in terms of pushing forward its artificial intelligence sector?
Yes, I do. I think that until we take a more proactive view, I think, in terms of what we consider to be eligible for protection, this kind of goes to the very heart of why we have intellectual property as a right. Fundamentally, we seek to reward an inventor or a creator for the works they create. When these laws were created and these concepts were created, these valuable works were your physical inventions, your artworks. Whereas now we're obviously in a digital society where key assets are now pieces of software, data sets, these cutting edge technologies. And, there's a reason why the US leads the world in this. And predominantly it's because they have a much more developed attitude to the protection of software as an asset.
Yeah. I mean, it's really interesting, isn't it? Because you're seeing a sort of very big battle, I guess, going on at the moment between Silicon Valley and China, and that's highly politicized as well, isn't it? But you can see you've got sort of one jurisdiction where patenting is like crazy, and then maybe China, or maybe you're going to tell me I'm wrong about this, but China maybe less of a formulaic approach to it. I don't know if I'm wrong about that actually, but. And you can see those two jurisdictions competing quite heavily, can't you, at the moment?
Yeah, you're 100% right, Sally. I mean, the biggest kind of downfall to the patenting system is the fact that you have to disclose your invention. So you have some very clever people in Silicon Valley being, unwilling to tell all and sundry how their magic invention works. So we are kind of in a cold war of technological development where people are hiding and keeping secret all the clever mechanisms that make their technology work. And you have to ask yourself, is that to the benefit of us if Google and the key players abroad are just keeping all of this technology hidden and only letting us see the bits that they can either commercialise or sell.
Yeah. So talk to us now, Matt, just about what organisations, the IP legal community is saying should be done, might be done in terms of extra laws around IP and AI.
So there's quite a lot of ongoing consultations and study regarding what we should do. I mean, as with any kind of legal system, we are kind of quite slow to put to suggest and to put anything in place. The UK IPO has an ongoing consultation at the moment. For anyone tuning in who's got a strongly held view on artificial intelligence, you can submit an answer to that consultation up until the 30th of this month. So you've got a week to get your views across to the UK IPO. They will then submit kind of what their views are, and then that will go through the usual processes, fundamentally to look at how we deal with it. The European Commission has been looking at this a bit quicker than everyone else. They've been looking at it for quite a while. They've increased from about 2018 to about now. They increased their budget by about 70% on the spending in terms of looking at artificial intelligence. Their current kind of commission spending is at about €1.5 billion a year, just on people looking at the area of artificial intelligence. They've got they're working with the World Intellectual Property Office to kind of look at how we can harmonise and work together. The latest kind of big meeting that WIPO held was on the 4th of November, and we're just waiting to see what the outcomes from that were. They will then submit various suggestions to governments around the world to see if we can harmonise. I think in terms of what we could expect, I think all of them will be seeking as how we categorise an artificial intelligence in a work of software. I think that is key, and it's important to stress that what I think a lot of people will be trying not to do is apply a very fixed, unworkable definition, because as we know, this piece of technology could change at the drop of a hat. And I think what we'll be looking at is trying to change our approach from looking at something in terms of what it is as opposed to what it does. At the moment, our intellectual property laws very much protect what something is, how it is made up, the line-by-line code in which an AI is derived from. Well, as Alan will know full well, and you may know yourself, presently you can have a piece of software copied, which is not line-by-line copied, but which, delivers pretty much exactly the same effect. And as long as there has been no copying taking place, that piece of software is, on a very high level, free to use, and that's perfectly fine because we've not copied the lines. It's a great frustration of a lot of our clients, app developers, software developers, who come to us and say, I've just created this very clever app or this very clever piece of software, and my number one competitor has just created something that does exactly the same thing. What can I do? And unfortunately, though we would love to reach to this, magic harpoon and say, we've got them. Unfortunately, as I said at the beginning, the law lags, unfortunately far behind where we are with technology at the moment. And, it's led to this situation where software as an asset is somewhat exposed. And I think that'll be one of the key things they look to address, is this kind of outcome-focused approach rather than looking at what the software is actually made up of. Instead, maybe ask yourself, what is that software doing? And is that relatively novel and new enough to warrant some kind of protection? Because I think without that forward-thinking approach, a lot of people will not see the reason for necessarily investing heavily in technology if they can't keep it confidential. The reason why a lot of the investment currently goes in to artificial intelligence and technology is done by people who are able to maintain its secrecy. Google are the masters of keeping things a secret, in that they've managed to hide from us how they give us exactly what we want when we type a few words into a box, for many, many years. And, that in itself is a prime example of how our system has forced Google into a practice. Instead of disclosure, we're left into a situation where they have to hide this from us. And as many people watching this will be aware, there's, ongoing outcries from a competition law perspective as to kind of how Google practice and the problems that that's created. So I think for me, that'll be the key thing that we'll be looking at.
I think it's really interesting, Matt, because you're talking about potentially moving more to a kind of look and feel approach that I understand they have in the US, where you kind of there's an element of protecting the ideas as well as the output. But I think and you've touched on it again, it becomes quite challenging, doesn't it? Because if you go to a more broader protection, which is what I think you're saying, you then run the risk that some of these very big dominant platform providers like Amazon and Google and Microsoft kind of start to dominate even more than they perhaps do now. And that, it's a really difficult conundrum, isn't it, for legislators, I think, right now, in terms of where do you get that balance? And I think we're certainly seeing that in terms of do you try to legislate now to regulate something before it happens, or do you wait and see if there's a problem and then retrospectively try and control it? Those are really tough issues, aren't they? I think for all governments. Yeah. Right, so for those of you who were hoping that you were going to get through a webinar without hearing the word Brexit, I'm very sorry to disappoint you, because Alan is now going to tell us, we managed to not say it for 22 minutes, that's quite good, but Alan is now going to talk to us about whether Brexit will have an impact on the development of IP laws around AI.
Thank you, Sally, and thank you for the B word pass, which I'm sure you're all very grateful for. I think Brexit's a really interesting one here. You're all sick of hearing about Brexit, I'm sure of that, but it's quite interesting. As Matthew touched upon, intellectual property law goes beyond the European Union. Actually, there's a lot more international cooperation than your man on the street might think, and the organisations such as the World Intellectual Property Organisation, they are looking at this at an international level, because artificial intelligence is going to impact everyone, not just particular regions, although some regions more than others, no doubt. So there's a lot of discussion at this international level, but when you bring it down a tier and you look at the European Union, again, as Matthew said, there's a lot of discussion at the European level. And what's going to be really interesting is to see what the impact of those discussions are, because if there's a suggestion that we change legislation, then obviously after the end of this year, that might not apply to us anymore, and query, are we going to seek to harmonise with the EU on this particular issue? Now, the EU is genuinely quite a friend of intellectual property law. The EU is very pro-business, and IP is typically quite pro-business as well. So whilst they seek to manage the conflict between competition law and IP, generally speaking, the EU is very IP friendly. However, we have seen a few instances in the digital age where the EU has taken a stance on IP, which some have felt is, whilst pro-IP, is perhaps counterproductive. So there was a lot of discussion last year and the year before about the censoring of the internet. You might have seen this was about a change to copyright legislation in respect of unauthorised replications of works. Now, from a rights holder perspective, the rights holders were very pleased about this, but from a stifling the internet perspective, there was a lot of people who were concerned, and there was a campaign started in response to that. So it does raise the natural question, which is, after Brexit has happened, would the UK government in that situation seek to follow suit? Would they uphold the rights of the IP community and risk a chilling effect on development? Sally, you touched upon different territories' approach to this and what impact that has. And it does open a question as to what attitude the UK government's going to have, given that it will be free from the shackles of the European Union, because it might seek to adopt a stance which is pro-innovation but perhaps not pro-IP, or perhaps it will seek to strive a balance in a different way. So I think Brexit's going to be really an interesting one on this sector generally, and boiling it down to very basic levels, at the moment intellectual property law is harmonised across the European Union. Our trademark legislation, copyright legislation, patent legislation, a lot of them, are trademarks in particular, are heavily dominated by European law. So it's going to be really interesting to see when inevitably there is going to be some divergence of laws, because whilst at its core, I think most businesses and the judiciary in the UK will seek to harmonise with bare principles and key concepts of IP law. I can readily foresee a situation where in 5 years' time, for example, a question is put before a judge, and given that we operate in a common law system, he or she applies a judgment to that which wouldn't have been replicated at EU level, and given that we're no longer bound by them, then sets a UK precedent on a particular point, particularly in copyright law. I think this is a very likely outcome. So I think it's going to be interesting to see what happens with Brexit. There is a clear opportunity for divergence between the UK and the EU. I do think that this will all operate within the international framework because, of course, we are now part of global Britain, so we will no doubt seek to have a input in that. But when it comes down to bare basics, the UK judiciary will no longer be guided by the European court system, so they can make their decisions in accordance with the British judiciary. So invariably, I do think there will be an impact, but I don't think we'll feel it just yet.
No, so it's kind of business as usual for now, but wait and see what might happen at some point. That's really helpful. Let's move on then to talk about how best to protect intellectual property and capture it, as you say, Alan. What should you be thinking about in relation to AI specifically? Let's look at it from the perspective of a developer. To begin with. Do you want to just talk to us a little bit about that?
Sure. So we do a lot of work with clients on an IP audit perspective. Clearly, IP is a very valuable asset and businesses want to make sure that they own it. And applying it to this particular scenario, your developer scenario, the first question, and indeed this applies to any IP audit scenario, the first question you must ask yourself is who is going to be generating this intellectual property, whether it's going to be an employee or whether it's going to be a third party. So if you're dealing with a business where there are lots of employees who are talented and are able to generate these materials, then that's great because you are typically able to rely upon the employee-employer presumption, which right law, for example, that the employer will own the intellectual property, the copyright generated by the employee, which is helpful. Where you start to get into the grey are if you are involving third parties, so if you've outsourced or you've got a consultant in for the day who is a consultant, not an employee. And importantly, when you start to deal with work that's being carried out outside of usual duties. Now, there's a lot of law in intellectual property legislation, and it's important to stress that IP rights, whilst there's a lot of similar themes across the various IP rights, this particular question of employee-derived works, there are nuances to each of the different intellectual property rights. So I'm going to talk in general terms here, but I would stress to the viewers that it's important to bear in mind that this is a broad brush approach and that there are subtleties to take into account. Notwithstanding that, if you have a scenario where you have developers and they are creating something, typically it's going to be quite obvious that they're creating works in accordance with their normal duties. They're doing their job and IP is arising as a result. Where it's going to get more interesting is when employees are doing things which aren't necessarily part of their normal duties. And the classic example you would have in patent terms would be the inventor who, she on a weekend, goes into her shed and invents something. Query, was that carried out in the course of ordinary employment? And I think it's going to be really interesting to see it in this space because obviously a lot of it is done on the computer. It's accessible. People can do it, subject to them having the required skills, of course. And of course, all of this now is viewed through the context of COVID, where everybody's home working. So the clear delineation between, well, I did it in my workplace, therefore I must have done it in the course of my duties, well, that doesn't necessarily apply anymore. So, and particularly given that we're all being told about the merits of flexible working. So if I happen to be a night owl and I do this at 1 a.m, query, was I doing it in the course of my employment? So I think there's going to be a lot to consider for developers in this space, but your core pillars, if you're a business who's operating in this sector and your employees, well, hopefully your employees are generating this material, your first question that you should always visit is who is developing this material, and are they employees or are they external? And that's your guiding principle. And once you address that question, the flow chart of what happens next follows very different routes, but that's a really important first step.
That's really helpful, Alan. We touched on this before, Matt, we've talked about, there's likely to be maybe some developments around intellectual property and AI and how that might look. But what's really interesting, I think, in this space is the IP that's generated by artificial intelligence, or even, I mean, I said at the beginning we don't know to talk about robots, but clearly there could be a scenario a robot creates something as well. What happens there? What's the position on that? And I'm thinking about a new invention, potentially a piece of work, you know, maybe an AI could write a book, I don't know. But also I think what's quite interesting for a lot of businesses is a generated database. I'm quite interested to understand what you think about that, because clearly a lot of businesses are looking to machine learning tools to manage databases of information. And it isn't any longer just a question of putting that information into that database, taking out the same information. There's a lot of activity going on there in terms of creating new information, new maybe sub-databases. And I think that is going to be really an interesting point. So looking forward to hearing your thoughts on that, and again, what businesses might do to sort of mitigate positions.
Yeah, definitely. I think, you know, you hit the nail on the head there at the end, Sally. Kind of, I think this is an exercise in mitigation. I think we're very fortunate in that we've recently had a case in the Court of Appeal in the United Kingdom regarding a technology that was created by artificial intelligence. For any of those who wish to go and read the case, it's a case called Thaler and the Comptroller of General Patents. The case itself, at its core, related to the fact that Dr. Thaler, who created a artificial intelligence, he called it Dabus, and Dabus was programmed to generate and create inventions, and following it doing something particularly clever, Dr. Thaler worked with his patent attorneys to draft a patent. And instead of doing the usual thing, which is what a lot of people do in order to kind of get over the issue of artificial intelligence is not being considered legal persons, Dr. Thaler actually put Dabus's name down as the inventor. So we're left in quite an interesting situation where Dr. Thaler himself was seeking to become the proprietor of the patent, the person who could use it and enforce it, but he wanted, at his core, he said he was morally obligated to give the credit to Dabus. And unfortunately for Dr. Thaler, the law is currently drafted and is interpreted by the Comptroller of Patents and at first instance and at the Court of Appeal, was that that's just not the case. Unfortunately, Dabus does not meet the requirements to be considered a legal person. So Dr. Thaler, unfortunately, was left in a situation where he's filed a patent and disclosed, you know, the secret source, and he's now left without patent protection. So that in itself is the key concern for a lot of our clients and a lot of businesses, in that if you get this wrong, and if you don't quite get patenting right, as an example, you can end up in a situation where you have disclosed your invention and you fundamentally then fail to obtain protection. So the question becomes, as we said at the beginning, how do we mitigate this risk? And I think it's quite clear that the key concern that's come out of the Thaler decision is that if you are left in a situation where your artificial intelligence has created something, I think you need to be very clear as a business as to who in that situation, as your business, as a real legal person, is going to be the person to hold their hand up as the inventor. You're going to need a very clear policy or a very clear organizational structure in place, which quite clearly shows that the following person or employer or business is the owner of that artificial intelligence, and therefore, by virtue of our current law, they will be the ones who own the invention. And I think it'll be important for businesses to get that right. Because if not, they may find that if they have used an artificial intelligence to generate an invention, and they then, if they don't own that artificial intelligence, for example, or perhaps there's a disgruntled former employee who created that artificial intelligence outside the terms of his employment but left it on the hard drive at work, there could be a serious issue as to patent entitlements. Someone come out of the woodwork. Alan's smiling because he knows how often this happens when, disgruntled ex-employee or former business partner pops up out of the woodwork and says, aha, actually I'm responsible for this rather clever bit of technology at your business. And you'll find if you look at the documents closely that you've got no entitlement to any inventions created by this artificial intelligence. Therefore, I'll have my cut, or usually, as so happens in these cases, I'll have my rather large check now, please. So it's very important that I think businesses address this issue head on and look very clearly as to how their intellectual property is being developed within the business. This is a key underlying principle that we try to give, instill in all of our clients, in that if you have people or you have technology in your business that's doing something a bit clever and is, potentially going to create something that could be valuable, you need to be very clear about who's going to own that. And I think honesty plays a big part in that. Actually sitting down with your employees and your partners and saying, look, who is going to own this? How are we going to deal with it going forward? And I think by doing that, you tend to kind of swerve 99% of problems. The majority of problems that me and Alan deal with tend to be when those conversations haven't taken place, and they then subsequently take place when either there's a lot of money on the table or there's potentially a big issue over infringement, for example, and everyone's trying to point the finger at the other. That is not a great environment to be then talking about the finer points of who's created what and who's responsible. So I think in terms of kind of AI-generated intellectual property for businesses, that's kind of how I would approach it. Yeah. And I think just to close off that point, you mentioned in the introduction to this point that, can artificial intelligences write stories? And the answer to that is yes. There's artificial intelligences in place now that people have set to task writing books, composing pieces of music, and that is creating both a lot of interest online. If you go on YouTube and type in artificial intelligence created music, you'll get some fantastic tunes. For me as an intellectual property lawyer, because unfortunately I have an unhealthy interest in this kind of area, it causes me great concern. And it's something that people are starting to address and become a little bit concerned about. Because as I mentioned at the beginning of this talk, the traditional bargain in intellectual property is that you are rewarded for the hard work you put in and subsequently given a legal right to either monopolise it or make some money from it. However, if you've got a piece of software or a piece of technology that can churn out 100,000 tunes in a day, effectively monopolise. I mean, we were already seeing these problems in the music industry where we have modern pop songs being accused of copying, harmonies and riffs that have been around for quite a long time. Ed Sheeran is, a particular culprit in this area. And
for many reasons.
Yeah, allegedly, yes, it's fair to add. But and that's these are human-derived songs and human-derived harmonies. Well, these computers. I'll give you one example. There's an artificial intelligence in the US that looks at all the number ones that have ever been and has compiled a song. You can find the song on YouTube, and it basically tries to take all the key elements from the most popular songs of all time. And I've got to say, it's not that bad. But, we should all be very concerned, because if the law takes a sharp left turn and all of a sudden AIs, or there is a much more clear protection of AI-derived works, then all of a sudden you could find that a lot of things like music, artworks, there's another one, could be snapped up in an instant, in that, the way that intellectual property currently works is that it's a first to kind of file system. So if someone gets there first and monopolises every harmony and every riff that you can use, how are we going to allow people and free people up to use those in the future? And fundamentally, how does that sit with the general understanding that you are rewarded for the hard work that you put in? Because I'm yet to see an AI, expel the bead of sweat that many music creators do, or have the tortuous love affair that leads to their second album. These are computers that are scanning and reading and pumping out output that, if we're not careful, could stop or could have quite, to use the kind of the the old adage to have quite a chilling effect, I think, on kind of creations going forward.
I think I'd just add to that. I think there's an interesting point here, which is fundamentally intellectual property law at its very core derived from the fact that it is property. It is a property right, and ultimately people generate intellectual property to a degree because they have a vested interest in the property right and the benefit that brings. If, however, you are in a situation where either A, the being that creates it isn't considered a legal entity and therefore cannot hold property, how do you deal with that? And B, onto the more moral question that Matt's touched upon there, if you have an entity that can create intellectual property but doesn't care about the property right at the end of it, where does that leave us? So I think there's some really interesting future problems here.
Yeah, and I think that, we're going to go now to talk about commercialisation, aren't we, of IP? And let's pick up this point that you and Matt have made, which I think is a really interesting point. When you take an AI software tool, for example, into a business, lots of businesses license now software tools from third parties. The thought that tool might create something that in itself has intellectual property beyond copyright, I guess, in documentation is quite novel. And so you can see, again, a real tension there, can't you, between the supplier of the tool saying, well, I want to own any inventions that come out of this, and the user of the tool wanting to claim that as well. And it's going to be a tricky one, I think, isn't it?
Yeah, I think the commercialization of this IP is really interesting. I mean, at its core, IP is typically commercialized in either an assignment, i.e. I'm going to sell you my technology, or it's licensed, as you've touched upon. Where you're going to see really interesting practices here, and you've touched upon this already, Sally, it's all the ancillaries that come with this technology. So when you give someone a license to use your AI product for a particular purpose, so the DeepMind example, I'm going to license you the usage of my DeepMind software for a particular clinical study in medical science. That sounds quite easy, doesn't it? But actually, we know that there's going to be a lot of elements that plug into this to make that work. And as a general comment, my advice would always be what it is in any scenario, which is certainty between the parties and a good contract. That is the best way to deal with this. But I think it's going to be really important to think about, and Sally, you and I have talked about this in previous webinars and also in the day-to-day practice, which is historically in a technology license, a supplier of a piece of technology may have just been content to say, okay, here's your product, Owen, here's a license to use the IP that's vested therein. Yeah. But what we're going to see now is a lot more interest in how that license is actually structured and what can the technology be used for, but more importantly, what can't it be used for? What additional elements are you going to need to make it work? And you've touched upon the improvements point as well. In a traditional scenario where two parties would come together and there'd be an exploitation or mutual exploitation of IP, you would typically have quite a clear understanding of improvements, and it would be something which is commercially negotiated, i.e. either the recipient of the technology would say, look, okay, I'm going to be improving this myself, so I want to own the improvements, and there'd be a discussion around there, or conversely, the supplier would just say, look, fundamentally, this is our technology. If you tweak it, sure, you can have a license to use it, but let's be clear, we're going to own this. But if you throw into the mix that the actual technology that you're supplying can, in theory, improve itself because it's an AI that can generate intellectual property, all bets are off at this point, and you're going to really need a good contract to deal with that. So lots of things to think about, definitely on improvements in particular.
I think it's really interesting, Alan, because you're looking at this from the perspective of entering into a commercialization license for a piece of intellectual property, which, is a tried and tested route, isn't it? There's lots of people do that. And I think what you're saying is what you need to do now is think beyond what you might have thought about in the past, because there could be other ancillary consequences of having a commercialization license for a piece of IP. I'm taking it in into my world, which is a software licensing and technology world, where you're licensing a tool. You're not thinking about commercially exploiting it, really. You're thinking about using it in your business. But now having to think about all of those issues around, well, what if it does generate some additional intellectual property? Can I use it? Do I have to pass it back to the supplier? What if it gets to so clever that it understands my business, that's a massive advantage for the supplier? That's way beyond what I thought I was doing in terms of just getting a tool to use in my business, and understanding the consequences of all of that and documenting that more clearly in your contracts than perhaps we've been used to in the past. And I think I touched on this in my introduction, is that you take a license to use something, you kind of accept you're probably not going to own any intellectual property that's generated or that the supplier generates. But now you have to think about, well, what about the algorithms in it? What about the libraries? What about all the granularity that makes up that tool? What happens when that does something that is very relevant to my business? Is it a confidentiality issue? All of those points now need to be thought through, not just in your world of commercialization, but I think also in my world of software licensing and SaaS and cloud and all of that stuff.
Definitely.
And I think that's just a massive issue, I think, for businesses to think through that. And I think that neatly takes, I don't know, Matt, did you want to add anything to that? Because I'm just conscious of time, and I did want to get on to the data point. Did you want to add anything to that?
I think just very briefly, I think it's important to stress the kind of the fact that these relationships are becoming longer and longer. I think, like you said, in your world of licensing software, you tell me, I mean, how long was your traditional software license, 5 or 10 years ago?
Yeah.
Whereas now, people are entering, it's very rare that you will ever get now a piece of software on a disk, in a box, you take home, you install, and you never have to speak to that developer again.
Oh, they're not normally perpetual now, they're typically term, yeah, absolutely.
So for us, that raises a massive flag in terms of business continuity and business value. If you build your business around something that your business fundamentally doesn't have control of, that is both a business continuity risk and it's also a value risk, because what happens if something goes wrong? What happens if you fall out with a developer? If this business has its tendrils in all the other, this piece of software has, or its tendrils in all elements of your business, or it knows your business better than you do, and you don't own it, you don't develop it, you don't have a right to develop it, you're entirely dependent on a third party to service that and to effectively keep your business running. And I think there's quite a lot of businesses that are probably in this position now without really realising it. Yeah. And I think just to kind of close on that point, I think for us that raises an issue time and time again now on a lot of the business acquisitions that we work on for clients. We're having to explain to potential purchasers of businesses what this means when a potential target says our entire business is built around a CRM system that's licensed. The value of our business is in the 100,000 contacts that are in our CRM, and we don't own this CRM. And we've only got a very limited right to the kind of, all the clever stuff that this CRM does. And, we're having to explain to potential purchasers what that means. The baseline point being that what happens if someone turns this piece of software off? What are you left with as an asset if you're coming in to buy that business? And that to me is very, very concerning. And I think if the people watching this were to take something away, it would be to maybe go and have a look at what software assets or what assets they currently utilize as a business but don't own, and ask themselves what would happen if someone pulled the plug on those in the next hour or so. How would their business cope, or what would their plan be, I think, more importantly.
No, good point. So we need to talk about data, don't we, in the last 10 minutes, because clearly data is so integral to artificial intelligence. And I think that what we've done typically in the past, before maybe artificial intelligence was so much in our minds, was have clauses in contracts, licensing contracts, that talk about all the intellectual property rights in the customer data remains with the customer. I'm guilty of having written that a few times in the past myself, I think. But what I think has happened is, with us understanding more about derived data, inferred data, the creation of data in these tools, the cleverness of these tools. What we're all doing, I think, is analysing a lot more of the clauses around use of data. And I think it's just important to sort of look at a few myths that there are really around ownership of data. And do you want to just talk to us about that, Matt, and just put it in perspective in terms of what ownership rights, if any, there are in data?
Yeah, sure. So I think Alan actually mentioned this very, very quickly when he spoke just now on the fact that, you know, confidentiality is over data is not itself a property right. So the right that you have to kind of administer and control data is twofold. It's number one, it's in the physical possession of the data. So you own a data set, you can license that data set, you can purchase data sets, you can sell data sets. Or alternatively, the second right is that, you know, is one of confidentiality. It's one of access, and confidentiality is not a property right. It's simply a question of, I have some secret information and I'm willing to grant you access to that secret information. So when we talk about artificial intelligence and we look at maybe what that could mean, there's a few concerns that have been raised. You've got to think of data in the sense of artificial intelligence as the food that we feed these artificial intelligences. It's how we train them, it's how we teach them. And the best artificial intelligences have been fed large data sets. They've been constantly fed data, and that allows them to essentially learn from the data, kind of the outputs that we want from them. So if you deal with, first of all, data as property, and you kind of look at that scenario, you know, you've got to ask yourself, well, where are we getting this data from? Who could be selling this data? You know, a lot of businesses are sat on very large, valuable sets of data and are just completely unaware of it. We joked the other day, Sally, about the NHS. You know, the NHS is probably the holder of some of the most valuable data in the world, yet at the moment are just not set up to commercialize or exploit that data in any way. There have been some key examples of them kind of giving it a bit of a go, but those haven't really been done in maybe the right way, or people maybe weren't ready for it, and that's led to issues. You know, when we talk about kind of medical data and data in that sense, you know, people are concerned. They've got privacy concerns. They've got concerns as to, you know, consent. And, you know, one of the concerns that's arising out of the United States is one of kind of data freedom. If we allow artificial intelligence generators to either purchase the rights to data and take that data off the market, does that mean that other people can't use it? Are we starting to approach a world where data could be maybe monopolized for certain artificial intelligences to become better than their competitors? And that raises a freedom risk, freedom of information risk. Looking at the other element, in one of confidentiality, it's a similar issue. If we start throwing shrouds over large amounts of information and data because we want to save them for our clever artificial intelligence, does that mean, therefore, that we're going to lose access to a lot of data and information? And then the flip side of that is that if we do feed information of this nature into an artificial intelligence, how can we ever guarantee that it will remain confidential? You know, there's the joke about, you know, as soon as something's on the internet, it's there forever. Mm. Well, if we plug data or we plug information into an artificial intelligence, you know, that is going to be there forever, and we're never going to be able to get that data back. So, you know, it's a concern, and you know, at the moment we are, you know, we're all still scarred a bit, I think, from the GDPR regulations that were brought in, and, you know, kept our regulatory teams very busy. But I think this could be the next big kind of question for people who deal in data. You know, for the people watching this, you know, if you have a look at your business, what data you have, you know, data is an asset that potentially, you know, you could make something from, or alternatively, it could be, you know, one of the weak spots of your business that you need to address.
Alan, have you got anything you'd like to add on the data piece?
No, I think I think Matt's nicely covered it all. I think as Matt touched upon, the difficulty you have with data is it's not like other forms of intellectual property where there is an inherent property right. So you just need to be very careful when you're dealing with it in contract in terms of ensuring there's a clear understanding between the parties as to who's going to own what. And again, it comes back to my point about when you're looking at this in the round and you actually realise that there's a nebulous of different things that feed into what you're doing, and having a clear understanding of the data is key, because as Matt said, it's valuable. People are very interested in this data. They want to use it, so that they want to have it so they can use it to feed into their algorithms, to their AI. So I think the data battle that Matt's referred to, I think is alive and well. I think it's already started, and I think businesses the entry level are going to have to start thinking about this. And again, we've not really touched upon competition law today, but I think where you're going to see ultimately, kind of, if we move into sort of final submissions, I think it's going to be interesting to see what impact competition law plays on this, because I think there's various bits of, as Matt's referred to, the big four control so much of the technology here, that I can really see a situation where competition law steps up to start to regulate various aspects of how this software, these AIs are deployed, because there will be various elements in it that for everybody who is watching this is personal freedoms are questioned, and it's going to be really interesting to see that tension. But no, taking it away from the stargazing and bringing it back to the day-to-day, the key takeaway from me on the data piece would be ensure there's a clear understanding between the parties, followed by a good contract.
Yeah. So I think that brings us to the end of the session. I don't think we've got any questions from anybody. I can't see anything. Just finally, top tips then, Alan. Two things, takeaways for you, and then two things maybe from you as well, Matt. You might be able to say two things.
Thank you for letting me go first then, Sally. So the first sort of, I would always say this in any, when we're dealing with, fundamentally this is a question of ownership. We're dealing with IP ownership at its core here. So your key question for me would always be, who is generating this stuff? Who is coming up with it? Is it an employee? Is it a contractor? Is it a third party? Having that understanding is really important. And the second thing I'd be thinking about is just being careful when you're dealing with third parties. And I mean that both in terms of their supplying to you, but also if you're in a position to exploit this technology by licensing it to others, just having a think about what it is you're giving people a permission to use. And you might be tempted to just roll out a very simplistic IP license, but as I've touched upon, and as we discussed, Sally, that probably isn't sufficient anymore. So just having a good contract to underpin this is really important.
Yeah. Matt, anything to add from that?
Yeah, two different points. I think I think the first point for me would be to kind of not be afraid to ask questions. The primer that you gave at the beginning of this talk, Sally, was, is the example I would give of that. You need to be willing, both as an advisor and a business, to not be embarrassed to ask questions about technology that your business is using or is potentially looking to use. And as I say, don't be afraid to break it down to basic principles. If it's a smart contract, if it's cryptocurrency, if it's artificial intelligence, all of these things are grounded in traditional mechanisms. They rely on contracts, they rely on data, they rely on software. These are things we understand, and the problems that we see arise are when people kind of get a bit ahead of themselves and maybe don't ask the questions or are a bit embarrassed to ask the questions. And I think we should all be a lot more willing to ask those questions. And I think my second point would be for people to think about that key issue I mentioned earlier about this kind of business continuity risk and this business value piece. I think people are far too willing nowadays to just tick the box for the T's and C's and sign up for these pieces of software that will have a massive impact on their business, without sitting down with someone like you, Sally, or someone like me and Alan, and thinking about actually what is this going to mean for my business in 10 to 20 years' time, rather than, what it's going to mean in the next 6 months, because these contracts nowadays are for forever, and unless they're properly negotiated, can be quite difficult to get out of, and then to also get that piece of software out of your business. So key takeaway from me would be to go and have a look at those.
Yeah, and I think from my perspective as someone who's sort of negotiated quite a lot on the customer side for software tools and licensing, I think those clauses around what you get access to, what you can and can't do with the tool, what you can and can't do with the data, what they can and can't do with your data are just so critical. And I think, for me, in conclusion, the law is a little bit unclear in some areas around all of this. And right now, because of the nature of these tools, it's going to be really important. I mean, you said it, Alan, and you've said it as well, Matt, really important to document very clearly what the position is, what rights each party has, and what they can and can't do in terms of exploitation and use, maybe outside of the internal business use. Those things are going to be really critical, it seems to me. And I think we've kind of got a little bit into a pattern of boilerplating that stuff because it's sort of the same over and over again. But we are moving into a world now where they need more thought, definitely. And you need to be addressing some of those points that we're thinking through, actually, and addressing some of those points. You almost need a kind of, like we do in the data protection world, where you do kind of a risk assessment of personal data flows. You kind of almost need a similar sort of risk assessment of deployment of some of this really clever stuff, don't you, within your business, and understanding the consequences of that and just being super clear about how that plays out. That was great. Well, I hope you viewers who I can't see, it's very, very strange doing a webinar when you can't see people, but I hope that you found something useful. If you do have any questions, email any of us. I think we might have got a question, actually. Just let me have a quick look. Just a compliment. Thank you very much, Frederick, for that compliment. If you've got any questions or you'd like to speak to any of us, you'll have our contact details. And thank you very much indeed for joining us. We hope you found it useful.
Thank you.
Thank you very much.